Okay, we're going to get started now. I want to welcome everyone. Thank you for joining the commercial lease negotiation webinar today. Today's webinar will discuss the San Francisco Moratorium and negotiation tactics for commercial leaseholders like yourselves. So thank you for joining us. My name is Julie Gilgoff. I'm the new staff attorney at Legal Services for Entrepreneurs, part of the Economic Justice team of Lawyers Committee for Civil Rights. And I have the honor of presenting with Jake Christensen, who is an associate at the law firm Arent Fox. They're one of LCCR's valued pro bono partners. If your small business is from another jurisdiction besides San Francisco, only part of today's presentation will be relevant. And so you should look out for future webinars that are specific to your jurisdiction. And as a disclaimer, this presentation is not meant to be taken as legal advice. It's meant to educate and provide information about the protections of the SF moratorium, offer strategies and negotiation tactics to use with your landlord. If you're looking for legal advice specific to your current situation, the Lawyers Committee for Civil Rights is offering no-cost commercial lease consultations together with our partner pro bono attorneys such as Jake. And we will discuss the application process of how to sign up for those consultations later in the presentation. So this presentation, so the agenda for today's presentation is to first focus on the initial steps you should take before you start the negotiation process with your landlord. Then we'll focus on the provisions of the SF moratorium as they apply to your small business. And lastly, Jake will offer some tips for negotiating with your landlord. As for questions, we'll pause in between each of the three sections, but you can write your questions into the chat box at any time. And Anna, our program staff, will collect these questions to pose to us during our breaks. So when you're getting ready to negotiate with your landlord, the first step is to review your lease. And when I say lease, I mean every part of it. Oftentimes there's a primary lease, there may be addendums, appendix. So you just want to make sure that you have the entire universe of lease documents to review. If you sublet your space from someone, which means you have a sublease with the person who is the original tenant, and they have a master lease with the owner or landlord, you want to review both leases that may include provisions that affect you as a subtenant, which may not be included in your sublease agreement. If you've leased your space for multiple terms, if you renewed your lease, you'll want to review each version of the lease that you signed. Oftentimes there's an option to extend without signing a brand new lease document, and it may be in the original lease that you've signed that includes helpful terms and provisions that I'll now discuss. And if you don't have a lease, this is a good reason to sign up for a commercial lease consultation. Your protections under the moratorium are going to depend on your agreement with your landlord and prior negotiations. Not having a written lease might give you options to terminate the lease that might interest you. But in San Francisco, the protections of the moratorium do apply to month-to-month tenants and holdover tenants, as I'll discuss in the next section. So as you review the written lease and all the appendices, there may be specific terms that you want to look out for. You can look out for these buzzwords and identify these provisions so that when you come to your consultations, you'll already have a head start. One such term is common area and other shared expenses, often referred to as CAM expenses, and sometimes denoted as additional rent. And this will be discussed in the same section as taxes or maintenance fees. Also look out for abatement terms. These are provisions in the lease that allow you to decrease the rent paid in the occurrence of certain circumstances, like if you can't access your building and if your landlord is cutting off services like utilities. So if there's any mention of abatement, this might also work in your favor. Also, keep your eyes out for the words force majeure, which literally means an act of God. A force majeure clause would excuse you from having to pay rent if there was an unforeseeable catastrophic event, which we could argue should include the pandemic. In terms of commercial frustration of purpose, if the purpose of your lease is to conduct your business and it was not possible to do so because of being in lockdown mode, this is another argument why you shouldn't have to pay rent, at least for the time that the shelter-in-place order was in effect. If you see any provisions that guarantee your right of access or use of the premises, then that would also be another possible reason why you shouldn't have to pay rent during those months. If you see a condemnation or casualty clause, which are extremely common in California and especially in San Francisco, this may also be of use. These provisions were often drafted regarding damage to the property if repairs weren't completed by the landlord within a certain amount of time. But some of these provisions may include access to the premise and loss of use during government action, which may be relevant to the circumstances of the pandemic. So again, look out for the condemnation or casualty provisions. If you're in a building with multiple commercial spaces, like a food court or a shopping mall, there might be provisions in the lease that require the landlord to meet certain obligations, like maintaining a certain level of occupancy that might be additional grounds for rent reduction. So failure to meet these occupancy operation requirements by the landlord can trigger termination and other rights in favor of tenants. Also, keep your eyes out for the term quiet enjoyment rights, which means that you have the right to inhabit your space free from recurring disruptions or disturbances caused by the landlord. If there have been significant disruptions or disturbances created by the landlord, this will be helpful to your case. And Jake will talk about this a little later, but you should look at the provisions regarding security deposits if there are any terms requiring you to repay it and in what time frame. There's usually language outlining when a security deposit can be applied to miss rent, and when a security deposit is drawn on, you have a certain amount of time to repay it. So review these provisions to understand how these funds might be used for rent repayment. For possible arguments outside of the four corners of the lease, it would be best to consult with an attorney for a 1-hour consultation. Examples of additional possible defenses regarding the terms of your lease could include supervening illegality, which is when a statute, regulation, or court decision makes the object of an offer, or in this case, a contract or a lease, illegal. Once you've reviewed these documents and looked out for these keywords, you're going to want to reach out to your landlord to start the negotiation process. It's really important to establish an open dialogue. According to the SF Moratorium guidelines, written communication is required to prove that you've attempted to engage in negotiations to come up with a repayment plan or reduction of the total rent that's owed. If you're not paying rent, it's important that your landlord know the reasons you're not able to pay the rent, such as pandemic-related financial hardship, a loss of earnings during the pandemic because of reduced hours of operation, complete closure during certain months, etc. In each month that you cannot pay the entire rent amount, it's important that you reach out to your landlord to explain your situation again, even if it's the same reason as the previous month. It's important that you continue to do so even if the landlord is not responding. As you gather all of this relevant paperwork and begin the negotiation process with your landlord, it's important that you make and keep copies of all relevant paperwork, emails, texts, scans of letters, and your lease in one consolidated place. And perhaps an online or a desktop folder would be best. So this might mean scanning a copy of your lease and all the appendices into a folder on your computer, taking screenshots of text messages with your landlord, saving emails with your landlord to this folder. Jake and I came up with a letter that you might use to send to your landlord that expresses that you're unable to pay the full rental amount because of pandemic-related hardship, and that you could send to your landlord monthly, and make sure to keep a scanned copy for yourself to put in this folder. Also, we suggest saving copies of voicemails as audio files. You might need a special app to save voicemail, so look into how to do this. But really think through if you've recorded and documented and then saved every type of communication with your landlord to document the outreach you have made to initiate and further negotiations. So next, we have left some room for questions. And yeah, Anna, if you can direct those questions to me and Jake, one of us would gladly respond.
It doesn't look like there are any questions right now, but we can wait for a few seconds to see if anybody sends anything.
Okay, great.
Yeah, I think it's okay to move forward, Julie.
Okay, great. So the next section we'll cover is the San Francisco moratorium. So what protections you're entitled to if your business is located within San Francisco. So right now, the protection of the moratorium extends through June 30th, 2021. It may or may not be extended, so we just have to wait and see. And this moratorium covers the rent that's missed from March 17th, 2020, the outbreak of the pandemic, to June 30th, 2021, for businesses that are financially impacted by the COVID-19 crisis, registered to do business in San Francisco, and have gross receipts at or below $25 million for 2019. So the protection, let's see, applies to qualified commercial tenants, subtenants, and month-to-month or holdover tenants. Rent includes monthly rent, additional rent, security deposits, late fees, and interests. If outstanding rent is still owed at the end of the moratorium or forbearance period, interest can accrue. So I'll go over the different tiered system in a couple of slides, but the forbearance period relates to the amount of time that the SF moratorium has allotted to your tier of business to repay all the rent that has accrued during the months of the pandemic. So for example, if you're a tier 1 business, which has 10 or fewer full-time employees as of November 1st, 2020, then you have a total of 2 years to repay all the rent that has accrued during the time of the pandemic, before any additional interest or late fees can also be billed to you. And if you have more than 10 full-time employees, then you have less time to repay, but the all of that is outlined very explicitly in the moratorium. So in order to claim protection under the moratorium, you have to provide written communication to your landlord. Financial statements or a letter from an accountant are not required. Written communication can include an email, a letter of the template form that we will distribute to all the participants today, or even a text message, as long as you record that you've sent it and provide a brief explanation in the text message. I'm not able to pay rent this month because of pandemic-related financial hardship. We're not getting enough. Our business is completely shut down for these months, or our business has not resumed full operation and we're not earning as much as we used to. So you have to provide those written communications to your landlord on a monthly basis. Discuss the payment terms with your landlord monthly. You might say, I'm only able to pay this amount this month, and maybe in the future, depending on if business increases, I will definitely pay more, but this is what I'm able to pay this month. And again, you must do this each month to qualify for the protections. You're not required to pay any rent during the moratorium, meaning that you cannot be evicted from the premise for failure to pay rent, but you're encouraged to pay what you can, since all the rent is accruing during these months and you will eventually have to pay them back. There are various sources of funding that you can apply to help you repay this rent, which Jake will discuss in the next section. Besides the protections that are outlined in the SF moratorium, the landlord can agree to additional extensions in their discretion. So again, the protections of the moratorium does not include rent relief. You still owe the missed rent. And so you have to look at the lease that predated the pandemic. So the landlord can't, for example, if the lease did allow late fees, you just have to look at what existed in the lease before the pandemic, and the landlord cannot modify existing leases after the outbreak. So the landlord can provide written notice that they plan to evict you and give you an opportunity to pay back the missed rent, at least 30 days to do so. But the landlord cannot evict you for missing payments while you are working with them. Work with your landlord to come up with a payment plan. If you still have not paid all outstanding rent after the agreed upon payment period or after the moratorium protections expire, your landlord can then commence proceedings to evict you for non-payment. So again, we could send everyone a copy of the 2020 Board of Supervisors ordinance, which creates 4 tiers of tenants. Tier 1 is 10 or fewer full-time employees. These types of businesses have 2 years to repay deferred rent, meaning within that time, you cannot be evicted for failure to pay all the rent that has been accruing during this time, and you also cannot accrue any late fees or interest for non-payment of rent. Tier 1 businesses also have the option to terminate their leases by giving landlords 30 days notice, as long as they are able to pay all the rent that's due during the termination date. If you're not able to pay all the rent that's due, you may also be able to negotiate what is a reasonable settlement. Maybe the landlord wants to look for a new tenant and would accept slightly less, as long as you raise some of these affirmative defenses, such as frustration of purpose. You shouldn't have to pay rent for the months that your business was entirely shut down through government mandates. Tier 2 businesses are businesses with 10 to 24 full-time employees, and they have up to 18 months to repay deferred rent without accruing any interest or penalties. Tier 3 have 25 to 49 full-time employees and have up to 12 months to repay deferred rent. And Tier 4 have 50 plus full-time employees, and Tier 4 businesses must pay deferred rent when the moratorium period expires, which is currently set for June 30th, but which may be extended. So we've already gone over this, that landlords can't assess interest or late fees for rent during moratorium period, or penalties, fees in connection with the termination of Tier 1 tenants' lease. So you'll remember that Tier 1 tenants do have that option to terminate their leases by giving landlord 30 days notice and repaying all the rent that's due or the agreed upon amount of rent. And usually there's an early termination fee, but if the Tier 1 business chooses to terminate their lease early, they won't be charged any of these fees under the protections of the moratorium. And again, landlords and tenants can negotiate, enter into agreements on terms different from those provided by the ordinance. If the parties can't agree, then the ordinance controls. And so, for example, the ordinance says that tier 1 businesses have 2 years to repay the rent. Maybe the landlord will agree to a lower rental amount, taking into account the months that the business was not fully operating, or maybe the landlord will agree to a longer repayment period, or at least to withhold any interest or penalties for the late payment of rent. So I see that there may be some questions at this time.
Yes, there is one in the chat, and it's about the moratorium. Can landlord pursue future rent after the tenant requests termination? Tier 1.
Jake, do you want to jump in?
Sure. So once you provide your written notice to the landlord that you intend to exercise the option to terminate as a tier 1 tenant, that notice will state that you will terminate 30 days from the written notice. And so any rent that is due up until that 30th day, when you turn over the keys and relinquish possession, the landlord can seek payment of that rent, but no rent or penalties or anything like that can be charged to you after the 30-day termination period expires.
And then the other question, what if I have not communicated with my landlord, or initially did, but not monthly? Am I still protected and can take advantage of forbearance period?
I can take this one too, Julie. So you're not alone if you haven't communicated with your landlord every month. Sometimes folks will communicate informally with them. And as long as the landlord's not pressuring you or saying that you're not eligible, it should be fine. In cases where there's been a gap or where you haven't communicated in writing each month with the landlord, I recommend that for the following month, you send a written communication, and to sort of cover your bases from the preceding months, just say, as you know, I've been unable to pay rent due to COVID related shutdowns and decreases in business, for the following months, or since March 2020, if that's the case, and just sort of paper that history. So you just want to have it in writing, and so that as we've discussed on XXX occasions, you can sort of outline that history of communication. If it was via a phone call or an in-person meeting, especially where you don't have a written text or email, it can be good to just sort of lay out that history of communication in the next month's communication, and then do your best to maintain that moving forward, sending the written communication every month. All right, I'll go ahead and share my screen. All right, and is that, Anna and Julie, is that displaying in full, or is it cut off at all?
It's in full.
It's in full.
Okay, good. All right, so feel free to ask more questions as we go through the presentation. We'll have another opportunity at the end to answer those. And so now we'll go into the final portion of the presentation, where we discuss how to go about negotiating with your landlord. And while this is geared toward tenants, a lot of these principles apply to landlords who are trying to work with tenants as well. And the key is just to sort of keep each other's perspective and situations in mind as you work to reach an agreement. So the first step in any negotiation is to get the other side to come to the table. And it can be helpful in preparing for that by thinking about what your best case scenario is, and also what your landlord's best case scenario is. In the case of the landlord, it's going to be to get full rent paid at some point, either through the repayment of back rent or moving forward. For you as a tenant, it's to get any sort of deal or reduction that you can to reduce your liability so that you can continue to operate your business and move back into profitability as things reopen and get back to normal. So in preparing to negotiate and to sit down and discuss these options, it's important to make a realistic ask. And the reason that we say this is because if you overcommit in the first instance, you commit to pay full rent moving forward once we move into the yellow tier, for example, and then also pay 50% of your monthly rent toward the back rent that's accrued. None of us has a crystal ball. We don't know how quickly or consistently business will bounce back as things reopen. And so you could get in a situation where you're not even bringing in enough revenue to pay the full rent and the amount you've committed toward back rent. And if you overcommit, odds are you're going to have to go back to the landlord and tell them, actually, I can't pay what we agreed to, and you have to restart the renegotiation process again. It inevitably happens in some cases. You can only plan so much, not knowing what the future holds. But to the extent you really take a hard look at the revenue coming into your business, increase in foot traffic, or if it's remaining steady despite the reopening, you can sort of create an accurate picture of where your business is currently at and where you think it's likely to go in the coming months, and just be upfront with your landlord about how you're basing your position in terms of what you need to make any agreement work. At the same time, while you're thinking of that realistic ask in terms of what you're going to be able to do, don't be afraid to ask for the best possible situation for you. The whole point of a negotiation is to find a middle ground. And if you start too close to where the landlord's at, you're going to end up more in the landlord's favor. If you're the landlord and you grant a series of concessions, then it may end up more on the tenant side. So if the landlord and the tenant can each sort of come with their best ask, you can then work together to find something that's going to achieve at least partially both goals on either side, and find something that's going to be workable for both of you. So some of the things you could consider asking as a tenant, one might be requesting abatement during the pandemic. In a lot of cases, businesses were forced to close whole cloth. They weren't able to operate at all during the government mandated shutdowns. And so at least during those periods where you could not operate your business because of a government order, that could be a request that you make, and then the landlord would forgive or reduce the amount due by that abatement amount. Some folks have also requested abatement for the duration of the pandemic, which is a bit more of a significant ask, since businesses have been able to be open more often than not in a lot of cases. So you want to be craft your best case scenario, but also try to be realistic and fair in what you're asking for. You could also ask for an extended deferral period in which to repay the back rent beyond what the moratorium, and in this case in San Francisco, the Board of Supervisors ordinance. So if you're a tier 1 tenant and you have 24 months to repay your rent, maybe ask the landlord for a little bit more time, with the idea that you would pay sooner if you can, but it just gives you a little bit more time to spread out that cost as your business gets back on its feet and starts to get back to normal. And at the same time, you could, in addition to asking for more time to repay the back rent, you could ask for rent reductions moving forward, either until the pandemic is declared to have ended, until the ordinance expires or is terminated, or until some other date, maybe through the end of the year, and then you would return to paying full rent under your lease. Some other tenants have also either through the landlord or through their bank or lender have converted unpaid rent that's accrued during the pandemic into a loan. One of those options that will show in the sort of available financial resources that has been popular is what's known as a EIDL loan, which is through the federal government. It's low interest. It can be stretched out in a long term so that the monthly payments are low. And that's a way to sort of get the landlord caught up, have all of your rent satisfied, and then also potentially leverage that repayment in one bulk payment of the back rent to get a lower monthly payment moving forward. So you can sort of compromise on one thing and then use that to try to reach an agreement on a foregoing basis as well, forward-going basis. You can also, in reference to a thing to look for in reviewing your lease that Julie mentioned, see if the landlord would be willing to credit all or part of your deposit toward the unpaid rent. If you look in the deposit section of your lease, oftentimes the lease will say that if the landlord has to use the deposit on file with them to cover unpaid rent, the tenant has a certain amount of time to pay that rent or the deposit back. And in this case, particularly if you have a large deposit on file with them, you could propose that the landlord credit that deposit toward the back rent. They already have the money. It's something that you can't access, but it's a way to leverage it to help you. See if the landlord would be willing to credit that deposit back toward your unpaid rent and then give you more time to repay it. So it's similar to asking for more time to pay the landlord, but instead they're getting that money toward the unpaid rents and just giving you a little more time to repay the deposit. Same idea, but it may be more appealing to the landlord. And you could also, in terms of the swaps that we talked about, propose the landlord forgiving a percentage or all of the unpaid rent if you promise to pay full rent moving forward, which we've also seen some landlords and tenants agree to successfully. If your lease is about to end, you could also propose to the landlord that you'll extend your lease or sign a new lease if the landlord reduces or forgives a portion of the back rent. The commercial vacancies in the Bay Area and specifically in San Francisco are still quite high. And so it's to the landlord's advantage to keep you as a tenant in a space that's already built out for your needs and uses. If the landlord has to turn the space over and build it out for a new tenant or update things that have changed in the code since you first occupied the space, that could lead to significant additional costs for the landlord just to get the space ready to release. And the landlord most likely is not going to be able to lease the space for the same price that you agreed to under your current lease, given the change in the market. So it could be a way for your landlord and you both to benefit by keeping you in that space. And at the same time, your business most likely has been in that space for a significant period. You have the built-in goodwill, the neighborhood regulars that come in, and all of that goes into having a successful tenant in the space who's going to be able to pay rent as things keep opening up. If your landlord, particularly if your landlord is asking what sort of government assistance or programs that you have applied for and received, we've seen landlords asking tenants if they've applied for PPP loans, which a portion of that can be used for rent, but not all of it for it to be forgiven. Other grants and things. It's fair for you to also ask the landlord if he or she's receiving any kind of assistance. Many of the big banks were and potentially still are offering mortgage assistance, mortgage deferrals for owners of commercial and other property. And so if the landlord's receiving mortgage assistance, that may make more of a case for them to give you some of that flexibility in working with you so you can both weather it. But the key is really that the landlord can't really bear all of the financial burden from not receiving rent, and the tenant also can't bear it all either in terms of paying full rent while your businesses aren't fully up and running. So it's finding a way so that both the tenant and the landlord can make it through and get back to what in most cases was a a great landlord-tenant relationship, particularly with tenants that never missed rent before all of this started, and only have done so because of the pandemic. There's great potential to go back to how things were before in terms of being a timely and just consistent tenant, and restoring that relationship despite the tensions of the last year. So going along with making an ideal ask and asking for your best case scenario, but making an accurate and a realistic commitment in reaching some sort of payment agreement. The example I mentioned earlier, where you would commit to paying full rent moving forward and pay half rent on top of that toward your unpaid rent. One option that we've seen tenants successfully propose is to tie the percentage of repayment to the monthly revenue. And what this accomplishes is, rather than saying you're going to pay $2,000 towards the back rent on top of your monthly rent moving forward, you would say, well, I'll put 5% of my monthly revenue toward my unpaid rent, and we'll pay off the total within 2 years. If the monthly percentage doesn't cover it at that point, then there will just be a balloon payment due, or we can consider renegotiating a longer payment term to finish paying it back. You could similarly ask to convert your base rent to percentage rent. And some landlords have been skeptical of this because, at least right now, in many businesses' cases, a percentage repayment scheme or percentage rent scheme would likely result in a lower rent payment to the landlord right now. But there's also a possibility where, as your business continues to grow and recover and things get back to normal, that the landlord, and as your revenue naturally grows with that, there is a chance that the rent that the landlord's bringing in based on a percentage calculation would exceed the monthly rent that was being paid before. And so if this is something that is workable for both sides, what I usually tell tenants to do to sort of figure out what percentage they would recommend for their base rent, I'll recommend that they go back to pre-COVID times, look at what their monthly revenue was, and compare that to the base rent set forth in their lease, and just divide the base rent by the average monthly revenue in 2019 perhaps, and you'll get a percentage, and then you can apply that to your current monthly revenue to sort of get a similar proportion in terms of how much of your revenue went toward rent, so that you're also able to meet your other obligations. If all you're doing is paying rent and you're racking up unpaid bills and other liabilities, that's not going to be good for the longevity of your business either. So getting a reasonable percentage rent that eventually, either after the percentage rent period expires, maybe you propose that you be on a percentage rent payment system through the end of the year or through the rest of the lease. Either you go back to paying the base rent on a monthly basis as set forth in the lease, or you would continue to pay the percentage rent and the landlord would earn more based on that as your business thrives. And same with the repayment. That's less crucial to figure out a reasonable percentage, but you could say, my rent was 25% of my revenue before the pandemic. So that's what I would propose paying out of my revenue moving forward. And on top of that, I'll commit 5% or 10% of my revenue toward repaying unpaid rent. Really, again, about whatever is going to be best for you, and try to reach some middle ground with the landlord so that you're not overextended. And at the same time, if you, the landlord, or you, the tenant, are trying to negotiate with the other party and he or she's just not working with you, not responding, particularly if the other side is being threatening or verbally abusive, communicate as much as you need to meet the moratorium requirements, which, if you're a tenant, that means providing the written communication at the beginning of every month, whether you're able to pay partial or no rent, and that you continue to be economically impacted, and leave it at that. As things overall improve, the relationship and just willingness to communicate and engage may get better, but sometimes you have to just pull things back a little bit and then try to resume those communications later on. The moratorium, as Julie talked about, does protect tenants from eviction for non-payment of rent. It does not extend to eviction based on nuisance or other violations of your lease. That said, if your landlord tries to evict you for one of those non-payment of rent reasons, and in reality it's because you're not paying rent, we have seen some landlords that have tried to pursue unlawful detainer or eviction proceedings based on those claims. And you just want to be aware of that. The housing courts have been on hold because of the moratoria in most locations in the area. As courts start to open up and the ordinance in San Francisco may end at the end of June, we could see courts taking more of these up. But as long as you qualify for the moratorium ordinance and it's in effect, and it really is a non-payment of rent issue that the landlord is seeking eviction based on, then you'll still be protected. But we have seen some tenants in that situation, so you can always request one of the negotiation consultations to discuss the specific facts of your situation. And so as we move forward and more folks get vaccinated, reopening in San Francisco continues. We have moved from the red tier to the orange tier, and likely we'll be entering the yellow tier in the near future for the first time. So it'll be new all around for all of us. And the OEWD office in City Hall has prepared a best practices webinar similar to what we're providing. It's about an hour long, and there's a recording that's available at this link. So you can log on. It'll sort of tell you the ins and outs of what it means for the capacity of people you can have in your business, what it means for outdoor and indoor dining, those sorts of things, but a pretty helpful overview of the requirements of the yellow tier. And so the most recent executive order issued by the governor extended the ability of cities to extend their individual moratoria through the end of June, which is why San Francisco's expires, or its ordinance currently expires then. There have been a series of executive orders from the governor that have allowed these moratoria to extend. We could see another one. Haven't really heard any rumblings on that. It'll really depend on most likely where the state is at that time. And in the past, I know in San Francisco, in some cases, they were extending the moratorium a couple of days before it was to expire. So it can be sort of last minute, but hopefully they will do it on an extended basis if they do extend it after June. At the same time, we sort of referenced the lack of courts reviewing these cases because of the different moratoria that have been in place, and going through the different buzzwords in your lease when you do that preliminary review. Some of those are related to defenses that you might have to the amount of rent that's owed. One of those being potentially abatement of your rent based on the language of your lease, where you were able to not pay rent when your business is not able to operate because of a government action or government order, which we've seen before. So there may be some helpful language in your lease that would reduce your liability if your landlord were to eventually try to expel you, or excuse me, evict you for non-payment of rent. So some of those may be more helpful and more successful than others, but still unsure how they'll work exactly. Similarly, there have been quite a few questions about the applicability of business interruption insurance. And this is something that many leases require that commercial tenants purchase. And as some of you may know, those policies have argued pretty strongly that it does not cover something like a government shutdown because of a pandemic. We've seen some court cases where the judges have agreed with the policyholders, but a lot of times this will depend on what your policy's definition of a qualified business interruption is. So it'll be important to take a look at that in addition to your lease if you have a business interruption policy. And even courts where some of the business owners have seen success, the courts or the individuals, the landlords, are appealing those decisions that have gone in favor of the tenant, or excuse me, the insurance policies are appealing those decisions. So it'll take some time to see how it shakes out, but it is promising that we have seen some business owners have success, at least at the trial court level. As we move to a greater scope of reopening, continue to research community financial resources and be on the lookout for new ones. We have existing programs that were previously closed for funding that have since reopened. We have new sources of financial support that come through fairly regularly from private donors or businesses, companies in the area. Additional federal funding that has come in, new state funding that's come in different budget years. So even if it's not open right now, there could be additional availability of different financial resources moving forward. And just from the San Francisco OEWD website, there's a COVID-19 for businesses page that about halfway down lists different funding opportunities, and some of them are specific to the type of business that you operate. So music and entertainment venue recovery fund, anchor storefront program, quite a few that go towards storefronts. And some of these are small, but if you accumulate several of them, it can add up to a significant support source. And a key with these as well is if it's a grant, it's something you don't have to pay back. You can just use it for what your needs are, as long as it's falls within these approved uses. But you see all of these include rent, payroll, taxes, all kinds of different things. And there are links to apply right on that page. We have the Save Our Stages grant program, PPP, which is the federal low interest and potentially forgivable loan program. And you can get significant funding through that. It also defers your initial payment. And if you use 60% of those funds for payroll, you can apply to have the loan forgiven. And similar low interest loans that we mentioned, one is the CA Rebuilding Fund. EIDL is another, and different interest rates depending on your for-profit or nonprofit status, and additional grants and other loans through the city and through the state. There is a specific coalition that is supporting local restaurants, and you can see what resources they have available and just different information at saverestaurants.com. And other grant and loan programs are listed on another page on the OEWD website at this link here. And for PPP applicants for this third round, if you haven't applied yet, it remains open until the end of May. So you have about another month if you're thinking about applying for that. That one is ideal because if you meet its requirements, it converts the loan into a forgivable loan and essentially becomes a grant. So that one is very useful for a lot of different businesses. There may be additional assistance and just information available to you through the Lawyers Committee's website, and that is accessible just by going to lccrsf.org. One of those resources is one of the free consultations that Julie and I have both mentioned. And in the case where you might need longer term assistance, either to negotiate with your landlord or deal with other issues, LSE does do some referrals for long-term assistance for volunteer attorneys who are able to take on those cases. But at the very least, you can get a 1 hour free consultation just to get your bearings, ask questions, and decide sort of what your next step is in this process. And additional COVID-19 business resources are available, same OEWD website. And this is, if you just go to oewd.org, there's a red button right on the main page that is business resources related to COVID-19. And this link will take you right to that page as well. And that's the end of our sort of negotiation section. I see we do have quite a few questions in the chat here, so I will go ahead and
Yeah, some of them were
those up.
more admin stuff, but there was a question: can the landlord challenge the ordinance controls and asking for more money after the termination date?
I'm trying to see what time was that put in so I can read
That
it.
was 3:20 p.m. Oh, sorry, no, 3:30 p.m. I can send it again.
Yeah, no, I see it. I've got the chart pulled up. All right, so this has been a common question about the option to terminate as a tier 1 tenant. Right now, it's not subject to any challenge that I'm aware of. And so some tenants have asked, how long will this be available? Do I continue to try to cooperate and reach an agreement with my landlord, or do I just exercise my option to terminate now? And again, don't have any crystal ball, in terms of what the future is going to bring. There have been some claims that the SF ordinance violates the California Constitution and the freedom to contract provision there. But as long as it's currently available, and it seems like it might be your only option, as long as you have reached an impasse in terms of trying to reach an agreement with your landlord, you can't exercise it. The landlord, as long as it's in place, still cannot come after you for rent beyond that termination date, however. So at least right now, as long as you meet the requirements of it and choose to exercise it, you'll be good to go. All right, so that was 3:30.
There was one more question in the Q&A. Says, you may have covered this, but if I'm a tier 1 and decide to terminate the lease, do I still have the forbearance period to repay missed rent?
That's our understanding of how it works. So it gives you 24 months after the ordinance ends at the end of June, assuming that it does, and then it also gives you an opportunity or an option to terminate your lease early. There isn't a whole lot of guidance on interpreting the ordinance, but at least that's the way that we're reading it. The only one where it requires that you have to pay, right away when the ordinance ends is if you're a tier 4 business. So that's the way that I would interpret it.
Those should be all the questions. All the other ones were directed for admin stuff.
Okay. All right. Well, thank you all for attending. If you have follow-up questions, you can always send them to the LSE email. And we encourage you all to sign up for a consultation. To any way that you can save on legal fees is ideal. So take advantage of that free 1 hour. And I've spoken with a lot of folks that we didn't need the full time, and I've been more than willing to let them use or reserve the rest of that time for a future meeting. So keep that in mind as well.
Thank you, Jay. Thank you, Julie. Thank you, Anna, for supporting. And everyone else, we will be sending the recording early next week with the presentation slides as well. And thank you so much for attending. Feel free to reach out to me if you have any questions. Bye.
Thanks, everyone.
Thank you. Bye-bye.